SJC-12015, Robert Cantell and others v. Commissioner of Correction and others.
Good morning, Ms. Tenerillo.
Good morning, Your Honors. I'm Bonnie Tenerello from Prisoners Legal Services. And may it please the Court, this is the most recent of a long line of cases in which the Department of Correction has tried to avoid giving prisoners in the harshest conditions of confinement the protection of the Departmental Segregation Unit, or DSU, regulations. The plaintiffs were held awaiting action in special management units, or SMUs, which are, again, the harshest conditions in the DOC. And because this confinement is equivalent to a DSU, the plaintiffs are entitled to the protection of the DSU regulations.
But haven't we said, I mean, we decided this case in LaChance. We said this is what they're entitled to, A, B, and C, and we basically tell the department they have to promulgate regulations consistent with those requirements.
Well, LaChance said two things. It said LaChance was deciding a federal due process claim, which was what was before the court. It was, of course, a qualified, an interlocutory appeal on qualified immunity, which rested on the federal constitutional claim, not on the independent validity of the regulations. And you're absolutely correct, Justice Cordy, that the court said the federal constitution requires reviews at least 90 days, and it laid out these new standards, and it said the DOC can conduct the balancing that we are requiring in regulations. It suggested the DOC could regulate in this area. Immediately in that same paragraph where it sets forth these new policies, it appended footnote 14, which said, when a prisoner is held awaiting action in a DSU, the DSU regulations still apply.
Could I just ask you a procedural question? This isn't working, so let me, if you can't, tell me if you can't hear me. LaChance, I appreciate the fact that it came up, because it was a partial summary judgment, Judge Murtaugh decided it, it came up, the Commonwealth was arguing no damages. Was part of the appeal the rest of his opinion, or were we only, was what was really before us only the damages question? I'm just trying to figure out.
It was an interlocutory appeal on damages. That was all that was directly before the court. But the court took the occasion, nevertheless, even while it said, here's the new federal constitutional standard, it took the occasion, as again in footnote 14, to say the DSU regulations are still there and still in effect.
For people held in the DSU. Your clients held in the SMU.
Well, yes, Your Honor, but of course, here we have to go back to Haverty, where the court, again, very clearly said, and this was cited with approval in LaChance. In Haverty, this court very clearly said that when you're held in the equivalent of a DSU, you must be given the DSU regulations. In the LaChance opinion, the court not only cites the Haverty holding with approval, but it also says the SMU was equivalent to a DSU.
And why would we have decided LaChance the way we did if the answer was, well, the DSU regulations apply, end of case?
I agree with Your Honor that
and we didn't.
This is a question, and our answer to this, and again, those of the reasoning of the court did give rise to questions in the Court of Appeals, the appeals court below. Justice Rubin, in his dissent, I think, had it right. What this court said was in that these new policies apply to restrictive confinement and awaiting action status whether, quote, in an area designated as an SMU, a DSU, or otherwise. But immediately after that, it says in footnote 14, if it's a DSU, then the DSU regulations apply. So Justice Rubin concluded, and we agree, that you may be held awaiting action in restrictive units or in your cell in restrictive conditions that fall short of a DSU, but when it's a DSU, the
But a
DSU
DS but a D-
regulations
but
must be
D- D-
provided.
People get to the DSU for entirely different reasons than the SMU, right?
Your Honor, I would respectfully disagree. The people are held in an SMU and in a DSU because they are thought to pose a threat if held in the general population to themselves, to the orderly running of the institution. It's in in the special management regulations that govern administrative segregation in SMUs. It requires that threat, and in fact, prisoners can await action and generally do await action on things like a disciplinary hearing or a reclassification in the general population. It is only when they pose a threat that they're held in the SMU under special management regulations, and it is that same threat that gets them into the DSU. And this court, I should say, there's a long line of cases where this court has grappled with whether prisoners awaiting action in confinement should get the benefit of the DSU regulations. And it's actually, Hoffer came, the Hoffer decision, which is where the regulations, current regulations were drafted to comply with the state constitution. Justice Liakos directed in Hoffer that the DOC regulate awaiting action in a DSU. And the DSU regulations that came out said if you're awaiting action, you can be held in a DSU, but you have to have a hearing after 15 days, or after 30 days if what you're awaiting is a disciplinary hearing. The regulations themselves coming out of Hoffer, and Justice Liakos in Hoffer, when he ordered the DOC to draft these regulations, referred to previous cases where the court grappled with what happened, how long can you hold prisoners in awaiting action confinement? With Kenny, Royce.
Help me to make, I read about the SMU, and I've not gone through the regulations, but is there anywhere in the SMU that says it's solitary confinement?
The amicus brief of the ACLU and Mental Health Legal Advisors Committee addresses this, Your Honor. Solitary, the department does dispute the nomenclature, but when 22, 23-hour-a-day confinement
but is there
in your
anything,
cell.
I mean, I know that appears to be what it means in practice to be in the SMU, but if one looks at the SMU regulations, does it say that you must be in what you would characterize to be solitary confinement?
It provides for 1 hour a day, 5 days a week, out-of-cell recreation. That's what
Is by yourself.
you're single-celled. And again, this is why this court in LaChance agreed with the Superior Court in LaChance that under the terms of the regulations themselves, these units, the special management units, are at least as restrictive as a DSU, if not more so.
Is it fair, do you think it would be fair to characterize the LaChance, the 2014 LaChance opinion as dealing with the similarities between the two, enough to say you have to have a hearing, and enough to say, and enough to look at it to say this wasn't clearly established for this population, so you don't get any damages, but that the question of the specific question of that Judge Murtaugh decided, but I'm suggesting that we may not have, the specific question of whether this is similar enough to DSU regulations that under Haverty it applies on all of it, not just when you get the hearing, but all of it in terms of when you get out, all the rest of the things that are in the DSU regulations. That was kind of left open. and you're raising it here, but is that part of what you're saying? That that Judge Fahey was mistaken in sort of just getting rid of that?
Your Honor, I would agree that it was not directly decided by this court in LaChance, and I would agree that, yes, Judge Fahey should have addressed that issue before dismissing the case. I'm not certain that it's left open by LaChance, because LaChance is pretty clear in its affirmation of Haverty, and in order to hold that the DSU...
But except that, as you say, the DSU regulations have 15 days, 30 days. This one says it can't be more than 90 days. I mean, it's a different time period that it's talking about.
Again, and I believe what LaChance establishes, and I don't see any other way to read it fairly, is that there is one set of requirements that are required by the federal Constitution whenever a prisoner is held in restrictive confinement in a SMU, DSU, or otherwise, any kind of restrictive confinement. And then it says in footnote 14, but if it's a DSU, it has to have the DSU regulations. And again, you would have to overturn Haverty, really.
Did you have a
to say-
different case before LaChance came out? I know you filed your case before LaChance, the LaChance decision was issued. Did you think you had a different case before that case come out? Was it a Haverty case before LaChance was decided?
I think our claim that the regulations have the force of law was not affected. What we had argued, and which LaChance rejected, was that the DSU regulations are required by the federal Constitution.
But-
That avenue was foreclosed to us by LaChance.
But, I mean, the opinion in LaChance, I mean, it says, LaChance has asserted claims under the state and federal constitutions that he was deprived of his rights because he should have been provided with the DSU regulations. I mean, isn't that what his complaint was? His
Your Honor,
right to due process under the state and federal constitutions.
no, the complaint, Your Honor, very clearly claimed entitlement to the protection of the DSU regulations on their own. And I would say also that as a matter of state constitutional law, the Hoffer still stands. These regulations were drafted to comply with the state constitution in Hoffer, and
And a regulatory law, you would say as well. I mean,
as regulations, they have the force of law. That's what this court said in Royce. And in Haverty, what the court said was if the DOC wants to repeal these regulations, they need to go back to the single justice in Hoffer and vacate the judgment in Hoffer. And they have not done that. And in Haverty, this court said, look, back in 1995, the DOC tried and was denied permission. And in Haverty, this court said, we don't see any reason to think that was wrong, but you can try it if you want. And as a matter of state constitutional law, apart from the pure regulatory claim, which on its own, I believe, entitles us to relief. But
so you're saying, forget LaChance ever happened. It's of no consequence, period. We're going back to Haverty, and all of this applies, no matter what LaChance says.
Well, Your Honor, I'm saying that LaChance applies, the federal standard articulated in Chance applies more broadly than the DSU regulations. It applies to any sort of restrictive confinement awaiting action, whereas I don't see any other explanation for footnote 14. And I also believe that
Maybe it was a mistake. Maybe footnote 14 was a mistake. Maybe it's inconsistent with the whole thrust of the opinion. Maybe it's not correct.
Well, Your Honor, as well, I would say that in order to have that interpretation, the court would have had to have overruled Haverty. And I believe you can't read LaChance and say that it was overruling Haverty. If anything, it leaned on and relied on Haverty.
He said there's a balance of interests here that need to be, interests that need to be balanced. We leave it to the DOC to promulgate regulations that reflect the balance of these interests in connection with awaiting action status. But in no circumstances can someone be held for more than 90 days without a hearing. I mean, what the heck were we doing there? Just making it up and for no reason because this doesn't matter anyway.
I agree there is a tension, but I also believe that if this court meant to eviscerate the DSU regulations, it would have said so. And, you know, furthermore, you know, I just want to remind the court of the big picture here. You know, as the ACLU MHLAC amicus points out, this country is awakening to the harm of solitary confinement. Their brief lays out reforms across the country, including federal reforms, which very much echo the DSU regulations. To eviscerate the DSU regulations now would be a very big step in the
This
opposite
case
direction.
has nothing to do with the DSU regulations. Isn't that the point?
Your Honor, we have a claim to the entitlement of the DSU regulations.
Applied to a different circumstance.
To prisoners held in special
SMU, yeah, held in special, a completely different
which are
category
equivalent to a DSU, Your Honor.
in some respects.
Or, I won't argue further.
Before you leave, I mean, one of the dilemmas is people are in the SMU for a lot of reasons. They could be awaiting transfer, as with regard to Mr. LaChance. They could be there for many, many reasons. Is it your view that, is the core view is that they should get a hearing in 15 days, that part of the DSU reg should apply, or is it your view that the full panoply of everything in the DSU regs is applicable to each of the persons in the SMU?
I believe that the reason the DSU regulations were created was because this type of confinement, 5 hours a week out of your cell, is so harsh that you need a good reason to keep someone there, and they're entitled to a hearing at 15 days, whatever they're awaiting, unless what they're awaiting is a disciplinary hearing, in which case it can be put off to 30, and there is an escape valve for extraordinary circumstances. The commissioner or his designee can certify the extraordinary circumstances, and the hearing can be delayed further.
And that hearing would be essentially, is there just cause for this person to be held in solitary? Basically.
Yes, is there substantial evidence that this person poses a substantial threat?
But with the SMU, that threat may be nothing that they have done. It could be that they are threatened because other people are trying to hurt them.
If it is a protective custody issue, that is addressed, and we do briefly address this in our papers as well. The Blaney judgment and the DOC protective custody policies themselves limit segregation, as I believe it's correctly called solitary confinement, but they limit segregation and they address protective custody. So people held because they're in danger from other prisoners would fall under there. And there are protective, I just should say there are protective custody units as well. Excuse me, I'm sorry, Your Honor.
Well, I mean, I had this question about LaChance, but the reason that at the time, LaChance didn't fit into that was that he was the one who threw the pudding at the other fellow. I mean.
That's right, he was the pudding thrower. And there was never a determination of threat, and he was sent right back to the same unit with the same prisoner who he was said to pose some sort of threat to. If the DSU regulations had been applied, he never would have been held for 10 months in segregation, because but again, that's not the facts here.
One last thing, did you have a finding that the SMU conditions at the time your clients were there was the same as DSU? We had that in LaChance. Did you have that in this case?
Yes, that's what's so odd about this case is the Superior Court said that the conditions were the same and acknowledged Haverty's holding that where conditions are the same, the DSU regulations should apply, and then said we'd gotten all the relief we need from LaChance. I believe that there was, I cannot explain the reasoning there, but there is a contradiction.
All right, thank you.
Thank you.
May it please the court, Cheryl Grant for the defendants. Assuming this court reaches the merits, I would submit that the LaChance decision put to rest all the same arguments that was set forth in.
LaChance overrules Haverty?
No, we're not arguing that LaChance overrules Haverty.
That the SMU conditions that are referred to in LaChance are not accurate?
No, we're not arguing that the conditions, that there's no issue regarding the alleged conditions. And here, this was also, just in terms of this case, was a motion to dismiss.
Why wouldn't the DSU regulations apply then?
Because that's not the sole test, and that was also discussed in the Haverty decision. You have to look at the nature of the placement and the type of the placement. Up to the point of LaChance, pretty much all the cases that had been what the dispute was about, where the defense were submitting that the conditions are different. And then in the prior cases where it was reached, for instance, in Haverty, awaiting action placements were not at issue. Those were, in fact, sort of long-term classification-based placements that could have
11 months, long-term?
11 months would be considered, that could be considered a long-term placement. I think that's why this court in LaChance crafted new process that would apply to awaiting action placements.
Justification for keeping somebody 23 hours a day, 5 hours out a week. Why do you do this?
There's different concerns, there's different issues that could arise. Here, there's no facts regarding any of these plaintiffs as to the specific reasons why any of them were placed there. That wasn't alleged by the plaintiffs. You could have inmates that are in there for protective custody needs. You could have inmates that are in there awaiting a disciplinary matter. They could have stabbed an inmate, stabbed an officer, and now they're awaiting a disciplinary hearing. They may require a different placement.
Why wouldn't the DSU regulations apply?
A DSU regulation, you can't, under the regulations themselves in terms of the regulatory aspect, you're not allowed to simply place someone in a DSU because they're awaiting a disciplinary proceeding. And in point of fact, the DSU regulation itself actually expressly excludes a placement for that. That is a more of a generalized concern where you have to find the substantial threat in general. They're not placed in there due to any triggering event or an objective event, which you have here under the 423, which is the SMU regulation. 423.08 has specific reasons. So it's not just some generalized concern that potentially for the entirety of your incarceration that you may need to be in a DSU, which could happen with a DSU placement. With an awaiting action placement, it's there pending an administrative event, some triggering event that occurs that in addition for the safety concerns that may be attendant to those specific needs in that instance.
Department, I mean, as your sister has said, there is a whole lot of research about the deleterious effects of keeping people locked up by themselves for 23 hours a day. What does the department do about that?
Well, why don't I just point out that there's no allegations in this case about that in general, but certainly there's been litigation about that. There's a separate statute in terms of mental concerns about, for instance, if an inmate has a serious mental illness. There was a litigation, disability law center litigation that was in federal court. There was a settlement. There's a whole host of procedures. 103 DOC 650 is the mental health policy. Inmates are screened before they're placed into any form of segregation to ensure that they don't have a serious mentally, that they are not seriously mentally ill. And that was actually sort of what came out of the Disability Law Center litigation, for instance, was recently codified by the legislature, where the salient points of that were put in statute. So they're not, this is they are seen by mental health. They're seen by nurses during rounds. And there's no allegation in this case that those concerns weren't met, that this case was simply about procedural due process.
Now, is there still a DSU?
Currently, the department has not operated a DSU.
Okay, so
in a while.
the persons who were in DSU before, where are they now?
Well, they would depend. They could be anywhere, Your Honor. I mean, if you have an
General
inmate,
population?
they could be in general population. They could be serving a disciplinary, a DDU sentence. I mean, there's really no way to know on the record. It would just really depend on how they've been proceeding through their incarceration.
Those who before were defined to pose a threat as to put them in the DSU, where would you put them now?
Those considerations that would have gone through the classification process, whether or not somebody needed a maximum security placement, whether somebody needed to be long-term housed in a protective custody unit. There are special units for that, for long-term protective custody needs that also goes through the
You're not answering my
classification.
question. You have a prisoner who previously would have been placed in the DSU because he would have met the criteria for going in the DSU. I assume you still have prisoners who fit that category, who would otherwise meet that criteria of being a threat. a long-term threat?
Well, they may or may not, and perhaps those inmates have committed disciplinary offenses and now in the DDU. We really have no way of knowing that on this record.
But am I correct that the folks who previously had been in the DSU are now going to the SMU because they pose a long-term threat? That
No.
those
No. And there's no allegation in this case, for instance, that none of these plaintiffs, that they weren't on awaiting action and that there really was no event and that we were just placing them in there for long-term placement. There's no claim in this case that we were using this as a guise, if you will, for DSU purposes. That's not claimed here.
But the question is, assuming that unless human nature has changed, you have people coming into your system who present the same characteristics as presented people who used to be classified and placed in DSU. Where do they go now?
Those would be things that would be considered in a classification process. They may be in a maximum security unit. And if, unfortunately, I'm sorry, what? Yes, they wouldn't simply be put into an SMU because there's some generalized concern separate and apart from some other triggering event, if you will, that is an awaiting action placement, which was what was discussed by this court in LaChance, in which, and I would disagree with my sister's argument that this was only that it was only brought forward to this court, LaChance, on federal due process. It wasn't just claims made in the complaint below; those were the arguments made to this court by the plaintiffs in LaChance. The court only needs to read their brief in that case, and even in terms of the
Deciding was whether there was qualified immunity, and that was, it was going to be under 1988, and so we were looking at
the plaintiffs, the court could have decided solely that said the case law wasn't established, and that's the only issue we're reaching. But the court went beyond that and crafted a new process. This was the exact same argument made by the plaintiffs in LaChance, and it was presented to this court at oral argument. During that argument, it was presented to this court in their brief. In their theory of the case, even for the federal due process, they argued in LaChance that the court didn't even need to reach the Sandin analysis and could rely solely on Haverty, and then they cited to Longval in terms of qualified immunity, and that under those cases they could get money damages. So I would submit that those issues were absolutely before this court when LaChance was decided, and that Judge Fahey was proper to dismiss this case because she found that the issues raised in this case in Cantell were the precise same issues presented to this court in LaChance.
When you had a DSU, was that a place in addition to a set of rules that were applied to the place? Were those people segregated not just individually, but from in a particular space within the prison?
My understanding from reading the case law, because it's not on the record in this case, and I can't avouch personal knowledge of that, is that yes, that there would be units or areas of the prison that would have been designated for those purposes,
Do those now no longer exist?
At present time, they do not. The department is not currently operating those. I unfortunately think it, as the court would look at, say even in Haverty, that there was some whether or not the efficacy of utilizing that and whether or not that was actually doing what they were hoping that the regulations would do. But those regulations still do remain in effect, and so if the department did have some generalized concern, and it's not based on just some specific event.
So wait a minute. Do you now have, in addition to general population, do you have another area where people are housed? And if so, what is that called?
Well, there are several different types of units, and certainly within different facilities, you obviously have different security levels, and there may be different privilege systems, if you will, even within different general population units. That there's certainly no claim that that any of those levels necessarily might be equivalent to a DSU, but there certainly are different levels, if you will, even of general population units, or you have orientation units, for instance, which might be when an inmate first comes into the custody of the department, as an example, where they sort of don't know much about that inmate. You need to look at the inmate's background and what is the best classification decision for those inmates when they first come into custody.
Does the department dispute the plaintiff's argument that the judge found in this case, that the SMU was not different from DSU?
I would
Do you
disagree.
accept that?
I would disagree with that characterization. This was on a motion to dismiss. There wasn't evidence submitted. There wasn't any hearing. The judge noted, sort of similar to this as this court did in the LaChance decision, that the conditions were similar. So the Judge Fahey noted that in her decision. I agree with that statement. I would disagree that it's sort of some type of definitive factual finding, but we're not, for purposes of this appeal, we're not disputing the similarity of mere conditions. But here the issue is the reasons for the placement, and that they can't simply, an SMU awaiting action placement can't simply extend beyond whatever that event is. If that event occurs, you can't just then keep them in there, because at that point, I would submit at that point, then you are looking at sort of a long-term DSU type of placement, because then it would be a generalized concern, and there's not some specific triggering or objective event that can be reviewed or looked at by prison officials, by the court.
To whom does, you say the DSU regulations are still in effect, yes?
Yes.
To whom do they apply?
Right now, we're not operating any DSUs. The department,
They don't apply to anybody?
no, if the department could choose to utilize them.
But right now, today, do they apply to anybody?
To my knowledge, they're not currently being applied to anybody right now, as far as I am aware.
So you've got the SMU regulations, you've
Yes.
got some protective custody regulations?
Yes, there's long-term protective for if they're classified as needing
You have.
long-term protective
What else
custody.
fits in this non-general management population regulation?
DDU?
I mean, you have the DDU, which there's not a separate DDU regulation. Those flow obviously from the 103 CMR 430, the disciplinary regulation. And within the SMU itself, there's also, which isn't an issue here, but disciplinary detention, which those are also housed in the SMU and actually have more, their conditions are actually harsher than what you would have for awaiting action. For instance,
Regulations for that?
those are covered also under the 423. So when you look at the 423, there's one section, they combine protective custody, the segregation awaiting action, and then there's also one for disciplinary detention inmates, which have, short sentences, 15 days for one offense or up to 30. And those particular set of inmates, for instance, when they're on that status, they don't get like personal phone calls or personal visits, whereas with awaiting action placements, for instance, they do. So that would be a couple of the distinctions.
Do you agree with your sister that there are people in the general population who are awaiting action? It's just that the crowd that is in SMUs presents some kind of threat or problem for the general administration of the prison?
Well, every time an inmate, for instance, gets a disciplinary report, that doesn't mean that you're placed on awaiting action. Inmates can be placed on awaiting action in their housing unit as well, and when those can...
Like sometimes people are there for transfer reasons, so that would be an awaiting action, right?
it could be, yes. So if it necessitates that.
Transfer people who are in the general population?
I'm sorry, what did you say, Your Honor?
So are there people who may be designated as awaiting action, awaiting transfer, but they are living as part of the general population wherever they may currently be?
Well, an inmate may be awaiting a transfer, but it may not necessitate a placement like that. Maybe they just,
Okay.
there's
That's maybe
hypotheticals.
not a good example. Are there people who you classify as awaiting action prisoners who are in the general population?
They might be in a general population unit. I would not say in that instance that they're in general population, because if you look at the 423 regulation itself at the beginning, in terms of its applicability, it applies not only to the special management units, but when they're housed in those same conditions in a housing unit. So, I think that you need to narrow in on the waiting action in those conditions, and not just the fact that some event is happening doesn't. I would agree that, yeah, that doesn't necessarily mean that you are placed in those conditions. One inmate may be recommended to go to another medium for program purposes.
What you're saying is if you are classified as awaiting action, these conditions apply to you wherever you may be, no?
Well, say you're not classified as awaiting action, that's a determination, but so yeah, that you would be put in restrictive conditions, but not just because there's some event does not mean that all those inmates are placed on awaiting action. I see that my time is up, so unless the
I
court...
just want to make sure I understand. You have, this is a motion to dismiss, so we have to accept as true the allegation that the conditions in the SMU are the same as in the old DSU, correct?
Correct, for the motions to dismiss purposes.
And under Haverty, if the conditions are the same, you get a hearing in 15 or 30 days.
No, again, it's not just the conditions, and that you needed to look at the nature of that. The awaiting action placements are not indefinite placements.
Okay, so
that's the key
so
distinction.
what you're saying is it's not the fact that they're in 23-hour-a-day custody that makes them in similar conditions. It is that DSU is a long-term commitment, and this is intended to be a short-term commitment. That's what distinguishes them?
Correct, and with due process principles as they are flexible, and that's why I would submit that they are different, and that's why I think that this court in LaChance was looking at an awaiting action that was a longer term and fashioned a process, a clear process that was clear as to the time frame, what process needed to be done that could be applied across the board, so that when you got to those awaiting action placements that might be longer in duration, that this is the process that could be used going forward.
Is there something that defines what a short-term, how long a short-term placement is?
I'm not aware of any definition, and I mean, the case law
My
prior
grandmother
to...
used to say, life is short. You could be there without any specific cap on it. You could, we'll take a look at it in 120 days and see if it's...
We'll look at it every 90 days, but you're there for 3 years. That could happen, right?
It's looked at every 90 days, and under the proposed, it's not just the first 90 days, but every 90 days. And certainly, if there's some claim that the department was delaying an event, for instance, he's in there awaiting a disciplinary hearing, and meanwhile, it's just been put forward for 3 years. I mean, certainly those would be something that could and should be challenged, and I think that the new process that came down from the court through LaChance is basically to narrow that down so that does not occur, and to make sure that that the awaiting action state placement isn't just an excuse, if you will, as what the prior cases have talked and taken the place of a DSU regulation, to ensure that it actually is for a specific event and terminates upon that event.
All right, thank you.
So thank you, Your Honor.
We'll
I
take
rest
our
on my
morning break.
brief.